And committing an act dangerous to human life, like driving into somebody's lane of travel when they're coming the opposite direction, is going to be a murder. Now, I don't particularly care whether you want to call that a murder or if you just want to call that causing death in the course of a felony. If you're more comfortable with that phraseology, that's fine. The judge has given you the definition of that charge. I believe we have proven to you that the defendant committed that crime. We're going to be asking you for that verdict at the end of the day. Now, the elements of the offense are set out for you in the jury charge. The elements of murder, the elements of intoxication manslaughter, the elements of simple DWI. I'm not going to go over all of that right now because there are a lot of common elements, as you've heard. And most of what we're talking about in this case is things that we are not arguing about. Nobody's trying to say that this didn't happen in Hays County or that it didn't happen on the 29th of September of 2014. The questions have been raised by the defense as to whether or not the defendant was in the course of committing DWI. So I'll talk about that more in a little bit. The other elements of the murder charge are that in the course of and in furtherance of the commission of felony driving while intoxicated, the defendant operated his motor vehicle in a way that was a clear danger to human life. He did that by driving into oncoming traffic on a public roadway. Said conduct resulted in and caused the motor vehicle operated by the defendant to collide with another motor vehicle offered by Nancy Sterling Dalton. Nancy Sterling Dalton kind of gets forgotten in a lot of the testimony that you've heard because we don't hear a lot about her. We had her son testify about who she was, identify this photograph of her. We had the medical examiner testify about his examination of her. I'm not going to show you those pictures right now. I do think it's important that we keep in mind that that is an element of this crime. That Nancy Sterling Dalton is a part of this crime as well. And Nancy Sterling Dalton was in that car with which the defendant collided. And in element 3, that act clearly dangerous to human life caused her death. She lost her life on this day. There is no argument, there is no potential finding that I think you can make that the defendant, in this case, did not commit an act clearly dangerous to human life that caused the death of Nancy Sterling Dalton. Now, the judge has given you some lesser included offenses. The reason for that is the judge doesn't decide what the facts are. The judge looks at the testimony and the evidence, says, is there anything that this jury could believe that would justify those offenses that I'm submitting? If you believe the defendant, we'll come back to this, when he says, she just slammed on the brakes in front of me, and I crashed into her. If you believe that, if you believe that this accident was Nancy Sterling Dalton's fault, as the defendant wants you to believe, then okay. He didn't commit an act clearly dangerous to human life, maybe. DWI, I think, is an act clearly dangerous to human life regardless of whether you leave your lane. But let's say you believe that. Then okay, you can find guilty of DWI. That lesser included offense is there because the judge isn't going to tell you what to believe. That lesser included offense is not there because that evidence is credible. That evidence is not credible. We'll talk about that more. I'm going to focus on the element of committed driving while intoxicated because that, I think, is where this case boils down to. That's what the arguments that you've heard have been about. These are the elements of driving while intoxicated as they're set out in that murder charge. Operating a motor vehicle, check, no problem there. Nobody argues that he wasn't. That it was in a public place. That the defendant had previously been convicted 2 times. That's been stipulated too. The judge told you must find that. So the only element remaining is, was he intoxicated? Had he lost the normal use of his mental faculties from the alcohol he ingested? Did he not have the normal use of his physical faculties because of that alcohol? Or was he over the legal limit? Now, what do you look at? What do you look at when you're trying to decide whether or not the state has proven beyond reasonable doubt that Jason Tarr was intoxicated? Do you look at whether or not he had slurred speech? Not alone. Do you look at whether or not he was stumbling while he walked, whether he couldn't maintain his balance? Not by itself. Sure, I'll grant you those 2 things, if you looked at in isolation, don't really prove very much. What you look at is everything. You look at all of the evidence. We talked in Gordire about how putting a case together is like a puzzle. When you put together a puzzle, you look at the piece and say, that looks like a piece of a puzzle that has a barn and some cows and some trees and some sky and clouds. No. You look at it and you try to see how does it fit with the other pieces. You try to see whether those pieces can fit together into a picture that makes sense to you. That's how you put a puzzle together. You don't just throw out the pieces because by themselves they don't prove the whole case. That's what the defendant wants you to do. They want you to say, look, he was drinking at the golf course. That doesn't prove anything, so stop thinking about it. Don't think about it anymore. Now let's look at the next piece of evidence. That he had this erratic, dangerous driving. There's other reasons why that could happen. Stop thinking about that because it doesn't prove he was drunk. Efforts to avoid giving blood. He didn't want to give blood. There's an explanation for that. He's definitely afraid of needles. So stop thinking about it. They don't ever want you to look at all the pieces together and put them together into a single picture and see what that picture shows you. What they want you to do is throw out every piece of evidence bit by bit so that at the end of the day you've got a table full of nothing. And of course, if that's what you have, then you would find not guilty. That's how they're going to ask you to look at this case. But that's not how we look at cases. We take those pieces, we put them into the puzzle, along with everything else that we've heard. Every bit of evidence, whether it goes to show the defendant was intoxicated or not, whether you believe it or not, we put it all together into the puzzle, and then we decide, what does that show us? Now, there are going to be gaps here. We don't know exactly how much he had to drink. You've been given some idea of that by some of the witnesses, but nobody has been able to tell you precisely how much Jason had to drink. That's fine. You don't have to know that. When you look at the jury charge, you will see there is no question being asked of you, how much did Jason Tarr have to drink that day? How many drinks exactly did he ingest? That question is never asked. You don't have to answer it. How much higher would his blood test have been if it had been done right away? Either at the hospital when they requested to do it, or upon initial request by Trooper Lashley, or at some other time prior to the 4 hours later when it was eventually done. You don't have to answer that question. You don't have to know exactly what it would have been. The questions that you have to answer are set on the jury charge in those elements. Those are the only questions you have to answer. But you have to do it by looking at all the evidence, looking at everything you have, putting it together into a picture of the truth that makes sense to you. And when you decide what you feel the truth is, if you believe that truth is that the defendant is guilty of this crime, that has to be your verdict. So I'm going to go over that evidence now. We know that Jason Tarr spent the day of the 29th of September of 2014 at a golf tournament. We know that there was alcohol available at the golf tournament. We know that he drank some of that alcohol. You've heard evidence that there were beer carts on the course. There were tickets given out, 2, 3, 4 different witnesses gave you different responses on that. We also know that there were alcohol tables at the tee boxes where people would get free drinks that they didn't have to spend a ticket on. We also know there was alcohol available at the awards. Now, do you have to know again exactly how much Jason Tarr had to drink? No, you don't. But you know that he was drinking. Did he drink at least 6, as you heard from one of the witnesses? Did he drink only 2, as you heard from another of the witnesses? You don't have to decide which of them is telling the truth about that particular amount. Neither one of them is very clear on that. Neither one of them expresses to you that they know exactly how much he had to drink. But you know that he was drinking. You know that he ingested alcohol. You know that because that is essentially uncontested by every witness who knows anything about it, except for the statements given by the defendant himself, if he denies it. We know that he stayed for some period of time. I'm going to say he left around 7:30 because I think that's what the evidence essentially shows us. We know that the awards began around 6:30, and we know where he is at 8 o'clock. So let's say 7:30 is when he leaves the awards. It doesn't really matter whether it's 7:30 or a little before that or a little after that. What matters is that at that point in time, you have different witnesses who are giving you different stories about what Jason Tarr was doing, but nobody tells you that Tarr was dancing on the table and picked up a pint of whiskey and downed it right before he went out to his car. That did not happen. Somebody would have told you that if Jason Tarr had shotgunned a bunch of beers, had taken a huge amount of alcohol right before he got in the car, you would know that. That's not what happened. The alcohol in his system when he left that golf course was alcohol that was starting, that he had already ingested. He is as much alcohol in his system as he's going to get. And then he leaves the Grey Rock golf course. He drives out to Slaughter Lane and over to the intersection of Slaughter and Brody. This is where he encounters Stan and Cindy Heitman. You recall they were testifying, we're getting ready to turn to the right. This truck pulls out from the left-hand side of us, cuts us off, and cuts down the lane in front of us. Because we're going that way anyway, we began to follow him. They're not following him like investigators, they just happen to be going in the same path. They continue to follow him down Brody to 1626, watching him driving, as they described it, aggressively, weaving, cutting back and forth into the oncoming lane of travel, pulling up behind people, getting close behind people that are in front of him, speeding up and slowing down, tailgating. And then when he turns onto 1626, it just gets worse. 1626, of course, there's construction going on. So the fact that it gets worse makes that conduct even more aggravating. Stan and Cindy Heitman turn to each other as they're watching this white pickup truck weaving in front of them. And they say to each other, he's going to kill somebody. We have to do something. We have to call somebody. What are we going to tell him? We don't know exactly where we are. We don't know what cross street to tell him. But he's going to kill somebody, and no sooner does that thought pass through their minds than he kills somebody. This is the overhead view of the scene of 1626. You can see this is a gentle curve. This is not a curve that, as a driver, leaves you blind as to what's coming towards you, particularly at dusk, when maybe people are putting on their lights, but there's still daylight according to Stan and Cindy. This is the view after the sun has gone down that Clint Hamilton, when he pulled up in his patrol vehicle, approaching in the same direction, from the same direction that the white pickup truck driven by the defendant Jason Tarr was coming from. Look at that curve. Look at that curve, and you're all drivers, you all know from your common experience, this is a curve that can be easily negotiated. This is not a curve that you have to be an Indy 500 driver to negotiate safely, even at speed, and they weren't going that fast. They were going within the posted speed limit, as far as all the witnesses tell us, for this road. This is a safe speed to be driving on this road. Any unimpaired driver should be able to negotiate this curve, no problem. Jason Tarr does not. Jason Tarr's car goes over into the oncoming lane of travel, crosses the double yellow line, the no passing line, and runs head-on into Nancy Sterling Dalton's convertible, crushing her between the front of the car and her seat, smashing her head, her chest, causing blunt force injuries throughout her body, breaking both her legs, and she dies there at the scene. You heard testimony about those massive injuries. I'm not going to show you pictures of them. Dr. Perez told you about that. Debbie Supernaw, the nurse who saw what had happened and stopped by to try to help. Roy Gay, the former police officer who saw the accident occur and then ran up to see what he could do. Stan Heitman and Roy Gay run up to help the defendant as well. And you can imagine what they thought. This truck flips up on its end. It's obviously struck something in front of it so hard that the entire back end of the truck was flying into the air. It slams down onto its side. Imagine how surprised they must be when they walk up and see Jason Tarr in the vehicle uninjured. Can't get out because the door is on its side. They have to help him by breaking out the sunroof of the car on the truck. He gets out, he proceeds to the guardrail, stands by the guardrail. Now he doesn't fall over. Some of these bystanders don't notice any strong smell of alcohol in him. You can only imagine what's going on. It seems to be described as chaotic. There's fluids on the ground, a breeze blowing, it's outside. The takeaway from this should be for you, I think, that the defendant, who we know had been drinking, was simply not so drunk that he couldn't stand up. He was not so drunk that he had so much alcohol smell about him that even outside, even not really paying attention to his breath, you wouldn't necessarily notice it. Does that mean he's not intoxicated? Does that mean that he had not had enough alcohol to affect his mental abilities, his physical abilities? Of course it doesn't mean that. It's very soon apparent to all the investigators, as well as, of course, the witnesses who saw it happen, that this wreck occurred because the defendant crossed into the oncoming traffic and smashed head-on into this red convertible as it's driving along exactly where it's supposed to be in its own lane. Just as soon, just as quickly as the police and the other witnesses realize that that's what's happening, Jason Tarr begins his efforts to avoid responsibility for this accident. You saw Officer Alvarez's video. Jason Tarr, yes, he walks to the ambulance. I don't know how he normally walks. I don't know if this is a very careful way of walking for him, or if this is the way he normally proceeds, but yes, he walks to the ambulance, doesn't fall over, gets into the ambulance, and then Officer Alvarez asks him to explain what happened.
Hey, sir, what happened? You all right? You know anything what happened?
Yeah, they stopped in front of me,
a car came in front of me, slammed on the brakes, makes a gesture like I just couldn't stop. Nothing I could do about it. Wasn't my fault. Now this conversation proceeds.
You were coming this way? In the view?
No.
You going to the office?
No. That way.
You didn't that way, officer, that way. You didn't that way, officer, that way. You going to officer or to view? Okay, you're coming in the view, and this red car was jumping in front of you, driving?
All Officer Alvarez is doing at this point is saying, can you confirm that I understood what you just told me? He's basically just repeated back what Mr. Tarr has just told him happened. Now there's confusion about which direction he was heading. The questioning by defense during the trial about that case suggested that, well, of course he was confused because he's sitting in the back of an ambulance. He didn't see the road. But you know, he had just been standing at the side of the road for some period of time and had just walked to the ambulance along that road. It's not like he didn't have a chance to view the road before he's in the back of the ambulance and leans over. Now, is he confused about which direction he was going? Because he wasn't paying attention? Because he's intoxicated? Those are questions you don't need to answer. But there are certainly questions that would have been going through the officers' minds as they're dealing with this situation. When he asks him to confirm, what happens is,
I'm just trying to figure out what happened. What happened there to it? That's all. No,
Mr. Tarr says, you want me to confirm the story I just told you now? Wait a minute. Because he knows it's not true. He knows that's not what happened. So now he's thinking, maybe this officer knows more about what happened than I think he does. I better not say anything else. Now this is before the EMS people ever say to the officer, hey, we need to check him out. You'll notice as soon as they say that, he backs off. There's no question here whether or not Officer Alvarez was impeding the ambulance personnel's ability to treat Mr. Tarr, because he does back off as soon as that issue comes up. So, to Officer Alvarez, Jason Tarr says, this car came to a complete stop in front of me, nothing I could do about it, it was her fault. It was Nancy Sterling Dalton's fault. She's dead because she did something wrong, not because I did anything wrong. In the ambulance, he's now talking to Emily Hyde. Remember, he has just spoken, just told Officer Alvarez his side of the story. What does he tell Emily Hyde? Well, I was coming home after golf, and the other person veered into my lane and hit me head on. So now it's not that she stopped in front of me. It's that she was coming the way I know she was coming, because I did hit her head on. I know that about Jason Tarr. But I want to make out that she's the one who veered into my lane. Suppose he suspects Emily Hyde hasn't inspected the scene. She's not a crash investigator. Maybe he also suspects Emily Hyde isn't going to report this to anybody else, what she said, or what he says to her. But you know that she does. She came in and told you. This is the story he told me. This is the second story, the second false story that he's given, the second effort that he's made to avoid responsibility for this accident. Now, the defense wants you to believe that at this point, when he's been taken off the ambulance, there are no symptoms of intoxication. You guys should just not find any reason to believe that he was intoxicated at the time of his driving, because there's no symptoms of intoxication visible there at the side of the road when this accident happened, when this wreck occurred, when Nancy Sterling Dalton lost her life because of this defendant's act of crossing into the oncoming lane of travel. His driving is a symptom of intoxication. The smell of alcohol that Emily Hyde noticed on him, now that she's in an enclosed space with him, now that she's able to spend some time with him where there is not going to be dissipation of alcohol, she can smell it. His blank affect, the expression that he had, the way he seemed disconnected from what was going on. The odd behavior, the taking pictures, the not asking questions, what is she okay? That sort of thing. The things that the witnesses told you struck them as odd. His confusion as to which direction he was going. These are all symptoms of intoxication. Now, are there other ways that they can be explained? Sure. If it weren't for the fact that we know he'd been drinking, we might be able to figure some of those out, use some of those other explanations. Some of those things may even be explained by other things, but all of them can be explained by the fact that the defendant had lost the normal use of his mental and or his physical faculties. All of them. You also are entitled, as the judge told you, to look at the evidence and decide what the weight you're going to give to that evidence is going to be. So somebody tells you something, somebody gets on the witness stand and says, this is a fact. You can decide for yourself, I believe what that witness says. And that's a fact as far as you're concerned. You can decide, I don't believe what that witness says. And so you're not going to consider that a fact. And you can do that with part, some, or all of each person's testimony. But what you can also do is, when you don't believe a witness, when you don't believe a statement that you've heard, you can ask yourself this question. Why is that person giving me a false statement? Why is it that I don't believe that? Is it because the person has a bad memory? Is it because they simply don't remember all the details after 2 years? Sure, that's possible for some of the witnesses. Is it possible that they have a bias in favor of one side or the other? Sure, that's possible for some of the witnesses. But it's also fair for you to ask, why does Jason Tarr deny any drinking? He's talking to a medical person when he's talking to Emily Petty. I mean, why does he tell her I haven't been drinking? I mean, he doesn't have to admit that he's intoxicated, right? He doesn't have to admit that he's drunk. He can simply say, I had a couple of beers at the golf course. But he denies drinking. He tells her he hasn't been drinking. She can smell it on his breath. And he denies it. Why is he lying to people about how he caused this wreck? Is that because it was just an accident? Is that because he knows what really happened? He's got full control of his mental and physical faculties. He's not worried about getting charged with intoxication, manslaughter, or getting charged with murder, getting charged with DWI. He's not worried about that because that's not true. But for some other reason, he's lying about what happened. You are entitled to look at those lies and decide for yourself, why would somebody give false testimony under these circumstances? And if that's because they're trying to hide their guilt, that's as good as a confession. Part of the reason why we don't have as much as you might otherwise expect from the scene of the wreck is because no one was actively looking for evidence of intoxication. Trooper Hart didn't show up and do field sobriety tests because they'd be in the field. He didn't do that because he didn't get there in time. Out of an ambulance who's about to go to Brackenridge Trauma Center and tell them, you got to get out and do the field sobriety test first because we really need to get this done right away. They're going to send him off to the ambulance, to the hospital, and figure it out later. Which, of course, is what Trooper Hart does. He asked Trooper Lashley to go to Brackenridge Hospital and continue this investigation, interview Tarr, find out what Tarr's version of events is. Remember, Trooper Lashley hasn't had a chance to talk to him because she's been in the ambulance too. So he may or may not have had Alvarez's version of events that he got from Mr. Tarr at this point. But at any rate, it's going to be important that he gets it from the horse's mouth. So Trooper Lashley goes to the hospital. He asks Jason Tarr to write him a statement. This is the statement that Jason Tarr writes him. Or this is the statement Jason Tarr tells him. Remember, Trooper Lashley said, I wrote it out. Asked him to read it and have him sign it, which he did. Highlighted there that what Tarr says is that a vehicle pulled out in front of me. So first the vehicle is going my direction, it stops. Then the vehicle is coming the opposite way and cuts into my lane. Now the vehicle is coming, I guess, across traffic and pulls out in front of me. So Jason Tarr wants to tell this story pretty much every way it can be told, except for the truth. Jason Tarr will accept any version of the facts that you decide in this case as long as it's not the truth. That's what he wants when he tells all these different statements to people.
Counsel, you've used 25 minutes.
Thank you. A vehicle pulled out in front of me, he tells Trooper Lashley. Now, Trooper Lashley knows the true facts. He notes the false statements. He smells alcohol. He knows that Tarr's been drinking, but Tarr denies drinking. He also sees his watery eyes. He says to himself, this seems like a DWI case. To any of you, it would seem like a DWI case. It sounds like that. He's weaving, he caused his accident, and I see these things. So I'm going to do the horizontal gaze and stagnance test. It's one of the battery of field sobriety tests. Can't do the walk and turn, can't do the one-leg stand test because he's lying in the bed, got a seat collar on. But the horizontal gaze and stagnance test is done. This is an evaluation that will be independent of any possible injuries that he has, because we know he didn't have a head injury because they checked it at the hospital. He observed 6 of the possible 6 clues for intoxication. Their own witness told you there is no reason to believe that lying down in a bed can't give you a valid result on the HGN test, except for the fact that the manual doesn't prescribe a particular way to do it. Well, take out the standing up part, you've got the way to do it. And that's what Trooper Lashley did. He does exactly the same thing as Dr. Kozlowski said that he did. He leaned over the bed and checked his eyes. Simple enough. So he obtains a search warrant to give Mr. Tarr's blood. While this is going on, Mr. Tarr is trying to leave the hospital. He has to be herded back into the bed. Again, he's trying not only now to avoid responsibility, but to avoid allowing evidence to be collected that will show that he is responsible. And, more importantly, exactly how and why he is responsible. He resists every effort to obtain his blood. He refuses the request in the ambulance to start an IV. He refuses Lashley's request to give a voluntary sample. He refuses Melissa Salter's request for a blood test at the hospital. He saw the Breckenridge doctors at 9 and 9:30, about an hour, hour and a half, not 4 hours after the accident, hour and a half. But he doesn't want that blood to be drawn. He doesn't want that sample to be taken. He doesn't want that alcohol concentration to be known. Why do I think this? Why do I think the evidence supports this? Because when they're asked to do these IVs, this is for medical purposes. And he's a patient. He's got problems, potentially, that we need to do this to get a better picture of it. We got to do this contrast with the CT scan because we'll get a better picture. In fact, Melissa Salter told you that there was a mass on his kidney that they saw during the CT scan, but because they weren't allowed by him to give him any injections, they weren't able to see it as clearly as they would have liked to. He claims that the reason for this is because of his great fear of needles, but remember, when his health is at risk, he wants it to be stopped because of his fear of needles, because he's, I guess, in a panic about it. But once he's told that your blood's going to be taken, I've got a warrant. You don't have a choice anymore. He calms down. Now he doesn't panic. Because remember, they didn't have to strap him to the table. They didn't have to hold him down to take the blood. Once he found out that it was inevitable, he submitted. Does that make sense? If the real reason is his fear of needles, would that fear of needles go away just because we told you, your fear of needles is going to come true today? No, that would increase your fear. That wouldn't change anything. So why is he so desperate to avoid this blood sample? Well, you know why. Because the blood sample comes back as .102. Now this is the first page of Exhibit 45. You have all 4 of the pages. It doesn't say 102 on it because, as Sam Salinas testified, that's the average. But the thing that I keep coming back to, despite all of the testimony from their hired expert, is that we have a blood sample result that was printed out at the very time, at the moment that that sample was running through the instrument, that has the same lab number on it as you see on Exhibit 44, the blood sample. It tells you where the raw data for that can be found, and it tells you what his alcohol analysis is for that sample. That printed out as the instrument was running. Not these summary sheets that printed out later, not these other reports and things like that, which I'm not going to belabor the point about how those reports ended up getting that information. But that very sheet tells you what his alcohol concentration was. It's 0.103 on this one. Now this whole thing about the calibration curve, remember what their own witness, Dr. Pittman, told you. That if you do this single point calibration curve like this, if you decide that that's your 0.8 because you test a 0.808 sample, you get a particular ratio at 0.08, that's what we're going to call 0.08. Now if you don't do these other samples, this multi-point calibration, then you're going to call that 0.10. Because that's where that ratio, when you get the ratio at the bottom, you follow it up to the point along the alcohol concentration where the 0.10 is, that's where it meets the line.
You can now use 30 minutes.
Thank you. If you adjust the line for the understanding that maybe the single point calibration isn't giving us exactly accurate results, all that's going to do is move the ratio down so that you might have to have a higher ratio to get the same number again. But what it doesn't do, what it will never do, is tell you that if that ratio is higher than what it was for 0.08, that his alcohol concentration is lower. It's always going to be higher. Maybe more higher or less higher, but it's always going to be higher. And all you have to decide is whether it was over 0.08, not exactly what it was. And granted, we don't know exactly what it was, because this 0.102 is done 4 hours later, because the defendant has resisted every effort up to this point to get his blood. It's 4 hours later that we're able to test it thanks to him. And that 4 hours later, there is no evidence of any drinking since he left the golf course. There's no evidence of any hard drinking at the last little bit of time he was at the golf course. There's no alcohol in the car. There's no bottles, cans, or flasks found at the scene. So if 4 hours later, you can use your common sense. Because Dr. Pittman has a PhD and gets up here and says you can chug a fifth of whiskey and not feel the effects or not have it enter your system for 2.5 hours, you don't have to believe that. You don't have to believe things that you know to be ridiculous. You know that if you are over the legal limit 4 hours later, you could not have been below the legal limit at the time you were driving.
Objection, Your Honor. That's under Monta versus State. It's an attempt at retrograde extrapolation. It's not possible in this case, and it's a violation of the court's previous rule. Overruled.
You know that over the course of that 4 hours, nobody, Jason Tarr, nobody else, is getting more drunk, more intoxicated, when they haven't had anything to drink for as long as he has. He is still intoxicated at the hospital. We know that from Dr. Kowalski's testimony, Dr. Day's testimony, and this blood test. How much more was in his system 4 hours before? We don't know. We can't tell you that exactly. But more? Yeah, more. Anything over 0.08 is a guilty verdict here. End of story. You don't have to decide if it was 10 or 12 or 15 or 20. Anything over 0.08 is a guilty verdict. And it can't be less than 0.08. Now, the defense gave an opening statement in this case, but they told you some things they were going to try to prove. I want to talk about that just a little bit, real quick. The defendant wants you to believe that his actions at the hospital are irrelevant, that his efforts to prevent anybody from getting his blood are irrelevant, whether he was intoxicated, trying to leave the hospital is irrelevant, the HGN test is irrelevant. Well, of course, he wants you to believe those things, but you don't have to take his word for that. He tells you that the testimony was going to be that Alvarez smelled alcohol and the defendant walked fine, but Officer Alvarez told you he believed the defendant was intoxicated. That was his testimony. They told you that Heitman suspected him of being intoxicated, but then they didn't think he was after they saw him walking around. And what did the Heitmans testify to you? That his driving behavior made them think he was intoxicated, and they still feel that way today. The defense told you the evidence to show that something else caused his inattentiveness and his bad driving. What evidence? None. No evidence has shown any other cause for what he did, for driving into Nancy Sterling Dalton's lane and killing her dead. There has been no other evidence of anything that would cause that other than the evidence of intoxication. Because some witnesses didn't notice the odor of alcohol, some did. Does that prove that he hadn't been drinking? Is that what they're really trying to say? No, because we know he had been drinking. Some witnesses said he was walking fine. Some said he seemed to have problems. Is he deathly afraid of needles? There's no real evidence of that other than what he has said. But there's no evidence of any panic from him once it becomes inevitable he's going to get his blood test drawn. The bloodshot, watery eyes, they say, that could be from his crying. Maybe he was crying. Except there's no evidence that he was crying. The defense cannot simply say, we have proven these things that we told you the evidence was going to show, because there's no evidence to the contrary. There's just no evidence to show those things. This is the defendant's opening statement. This is what they told you the evidence was going to prove. If the HGN test is ideally performed standing up, not lying down, okay, maybe. Results are unreliable. Everything that you have that would go to show intoxication shows intoxication. The officers, they say, found out about his 2 priors and lost objectivity. Well, I'm sure they suspected intoxication pretty quickly, but why continue the investigation? Why get the blood test if they were so convinced? It's because they need to confirm their suspicions. That's what officers and investigators do. Why wouldn't they suspect intoxication under these circumstances? I mean, if you found out that the officers in this situation just said, "Man, let it go," wouldn't you be shocked and amazed? You're telling me this guy was weaving, crashed into somebody and killed him? He's got an odor of alcohol in his breath? You guys didn't even bother to investigate whether he was intoxicated? That would be insane. That would be crazy. Nobody would believe that. The defense actually got up here in their opening statement and told you the DPS lab is part of the same agency that employs these officers, as if that somehow should cause you to discredit their results. And then they actually had the chutzpah to get Thomas Pigman on that stand, a guy who is the business partner of the defense attorney in this case. He doesn't just work for an agency that the defense attorney also works for. He works with the defense attorney. He was hired not to perform his own test, not to bring you the truth, but for the sole purpose of coming in here.
Actually, the defendant has no burden of proof in this case. We are not required to test the blood. That is the state's burden. It's inappropriate jury argument denying the switching burden of proof in this case.
I didn't hear him say that. What did you say, Nicholas?
Your Honor, I said that Dr. Pigman was not hired to perform his own test and come in here and provide a different test than what the DPS got.
That's not a comment on the burden of proof. Overruled.
He was hired for one reason and one reason only, to come in here and convince you that the DPS test was unreliable. That was it. That's his whole reason for being here. He wasn't hired because, well, we don't know. Let's find out. That's what the DPS lab people were hired to do. He was hired only to come in here and try to gin up whatever reasonable doubt he can gin up. Defense tells you this is a case about square pegs and round holes. Looking at evidence in a case like this is not a peg in a hole exercise. It's a puzzle. You don't pick up a round peg and say, well, I got a square hole over here, throw the peg away. You pick up the piece, you look at the rest of the puzzle, you see how does this fit in here. You do that because you find the truth by fitting all the pieces together. We know that there is a version of the truth. We know that the truth is out there. That there is something true that explains all of this evidence. We know that. That has to be the case. You take all those puzzle pieces, you put them together, you use your common sense. You draw your reasonable inferences from the testimony. You make your deductions. You reach your conclusions. And I'll tell you what you'll find is that the truth fits together. The true facts will put a puzzle together and they will all fit. Why did Tarr lie about what happened? Because he wasn't intoxicated? How does that fit? If he was intoxicated, of course, that's why he lied. Why did he lie about whether he'd been drinking? Because he wasn't intoxicated or because he was? Why was his driving so bad? The only reason you have is because he was intoxicated. All of these questions, why did Nancy Dalton certainly lose her life that night? Every question you may have in this case can be answered with one fact: the defendant was intoxicated. If that fact is true, this puzzle fits together. Every piece fits. Even the pieces where the witnesses didn't notice symptoms of intoxication, all that means is he wasn't so intoxicated that he was falling down drunk. But every other piece, including those pieces, if he was intoxicated enough to be unsafe to drive, the end. The verdict is guilty because Jason Tarr was intoxicated. If you don't believe that, you're going to be left with way more questions, way more pieces sitting off to the side that don't fit in whatever picture the defense is going to try to paint you. That's a big check mark, ladies and gentlemen. And because of that, when you go back to render your verdict, you should find the defendant guilty on the top count of count 1, guilty of murder, because we have shown you how a DWI turns into a murder and why that's what happened in this case. You must also convict on count 2, because there is no question that the defendant, by accident or mistake, caused Nancy Sterling Dalton's death because he was driving while intoxicated that night. There is no other explanation. Defense is going to get up now and try to convince you that there is. They're going to give you little explanations for each individual piece of the puzzle. They're going to try to discredit the blood test. They're going to try to discredit the ATM test. They're going to try to say this person didn't notice that, this person didn't notice that. But they are not going to give you a picture and say, here's how all the pieces fit together. They're going to ask you to throw the pieces away. That's not what jurors are to do. Find the truth, ladies and gentlemen. You know what it is already. Guilty, guilty.